known IPs that already exist. Let's talk about a few of them. We have confidential information. Every company, every business, every enterprise runs on certain types of trade secrets, something that they don't want to share with their competitors, something that makes them distinct from other people. So, for example, nobody knows what goes inside a Coca Cola bottle. Why is it that taste? Why is it that color? How is it that it tastes entirely different from the other bottled beverages that are available in the market? That is a trade secret. Coca-Cola will never ever disclose it because that is their USP. They can't disclose it. Similarly, there is something called plant varieties. There are certain types of plants that are being made every day. People are trying to cross existing plants to create new lines of plants that produce a certain type of result. For example, I don't want say I want silk, or I want cotton, or I want jute, but I want certain additional qualities in it. I can't patent it. I can't patent that new plant itself. But if I'm crossbreeding two plants to give me a certain quality such that, say, my cotton doesn't rot, or my cotton doesn't discolor, or my cotton holds the dye that is being used to color it in a better manner such that my clothes don't fade. These are all new varieties of plants that are protected under an act called the Plant Varieties Act. Again, that can't be patented, but there is a alternative IP that is available in India or even internationally to protect your intellectual property. Apart from that, we have something called the Traditional Knowledge Digital Library. Now what that does is, I don't know how many of you know this, but in US you can get a patent on almost anything. That's how, let's say, easygoing or flexible their laws are. But it's not the same in India. I, for example, have known the users of haldi since I think I was a child, and I think most of us have. But at the same time, in the West, people are discovering the uses of haldi. They're copying it from us. They're copying it from different cultures. Similarly, in the West, new and new properties of, say, ginseng, of ginger, all are being discovered. But you can't just go ahead and patent it because this is something that has been known culturally in the tradition of a certain locality or of a certain culture for many, many generations. Now, something like that cannot be patented because it's already known, but it can be protected as traditional knowledge, something that is very inherent to a culture or a tradition. In India, we are slowly trying to protect all types of traditional knowledge, including for basmati rice, for haldi, for neem. All these properties are now being protected under the digital traditional knowledge digital library. Sorry, and the only thing wrong with the TKDL is that it's sadly not available for public to access. So what happens if somebody tries to find a new medicinal property of a plant? You can't check it. How do you check it? Because that digital library is not yet available to the public. I will always think that, oh, you know what? I've discovered a new medicinal property of this plant. Nobody knew it till now. I've asked around. Nobody knows it. Nobody knows how to actually extract that medicinal property of that plant and use it. But it could already be protected or known under the traditional knowledge digital library. How do we access it? So this is another issue that probably we can tackle in another seminar. But what I'm trying to communicate here is, A, the word patent is being used extremely loosely these days, and B, it's not that just because your creation is not patentable, that does not automatically imply that there isn't an alternative IP protection that is offered in the country. There are different types of intellectual property rights that are available to you, and you can access any of them. So let's not focus on just getting a patent out of it.